great. We have some new faces. We have some original members here. So before we go any further, several of the things you guys said reminded me that I need to say nothing in this room is intended to be individualized investing advice or legal advice or tax advice. The whole purpose here is for Carlotta's going to come and share her expertise with us. Obviously, if you need individualized legal advice, you should hire a lawyer, right? We've never had any problems with that. I'll say that before everything. So I met Carlotta. I had a very difficult client who hired Carlotta to do part of the estate. And even though the client was difficult and that relationship kind of ran its course, like I was just super impressed with her knowledge and her energy, and just thought, oh my gosh, I want this woman in my life, and I need her in my network. So she's done a podcast for the Women on the Verge, the Financial Breakthrough podcast with my friend Caitlin, another awesome woman who's investing her member. She has always been willing to show up like this in a volunteer capacity to share what she knows. So I'm so excited to have her here, and now that we've been chit-chatting for 30 minutes, I'm going to turn it over to you.
Thank you.
Thank you.
Okay. Hi, everyone. I'm Carlotta Garza-Kilcullen, and I'm having crazy allergies, so I've got my water, but if you can't hear me, I'm a little bit hoarse, so bear with me. And I might be like clearing my throat. I'm not contagious. I'm just dealing with the allergies, all the flowers. But I'm excited to be back. I gave a very similar presentation last summer, so sorry. I recognize you from last time. Welcome back. Oh, thanks. Well, I mean, there's a few tweaks, but it's very similar. So if you get bored, I won't be offended. I'm an estate planning and probate attorney here in Austin. I'm in my 4th year of practice, and I really like my job. I like my work, and there's a huge need for information, and it's hard to find information. So my goal for today is to point you to resources that are free if that is appropriate for you, and if it's not, to help you decide, can I use and employ this free resource effectively? And if not, who should I get in touch with? So last time I gave my presentation, I got like 15 calls from people who attended, which thank you so much, but also that's too many. And so at the end of my presentation, I have a slide with information for some of my favorite attorneys in town, so that it's not just me. This is not meant to be like a sales pitch, and ethically, I'm not allowed to solicit. So anyways, I'm always love getting new client inquiries, and it's just me. So yeah, I have some great lawyers whose emails and phone numbers I've included at the end, in case you are looking for help and you want to check out a couple of other awesome people. And they happen to all be women, but that was not intentional. So yeah, a little bit about me. Before I went to law school, I was a high school teacher for 3 years. I taught English as a second language and Spanish for native speakers. So I love to explain things and educate and teach. Today's presentation is primarily educational. It doesn't create an attorney-client relationship between us, and I can't give you legal advice, but I am happy to answer questions. If at any time something I say is unclear, or you want me to explain it a different way, or you have like a scenario, I'm happy to take questions. Just raise your hand and we'll talk about it. Yeah, after 3 years of teaching, I decided I wanted to go to law school. So I went to UT Law here in Austin, and yeah, and now I'm here in front of you guys. I met Sarah, like she said, through a mutual client that was a really interesting situation, and it blossomed into a beautiful friendship. So yeah, thanks for having me back. Okay, let's get into it. So I do, like I said, I'm an estate planning and probate attorney. We're going to talk about estate plans first, and then we'll talk about probate second. So an estate plan is legal documents that cover emergency, incapacity, or death. So a lot of the time people think like, oh, I just need a will, or oh, I just need a trust. And you probably do need something, but you also need lifetime documents. So wills and trusts oftentimes are the operative document that disposes of your property after your death. But it's also important, especially for those of us with aging parents or who have caregiving in our stories, right? You need to have the right people in place if there is an emergency or a long-term illness or incapacity. And so we're going to talk about all the documents that make up an estate plan. I should also mention, since you did post the last one on YouTube, which I did, thank you so much. If you're listening from a different state, I'm only licensed here in Texas, but I will have information about other states, like resources to help you find information in other states if that applies to you. So let's get into it. So some people can get away with using the free resources that exist out there, but oftentimes there's a complicating factor that really does require an attorney's help, just because these things can make your plan a little more complicated. If you have a minor child, minors can't own property. So if in your will you do it yourself and you say, I give everything to my 5-year-old daughter, Amelia, and then you die while she's a minor, Amelia can't inherit that property directly, and it creates a ton of problems if a minor is set to inherit something outright in her own name. You need something there for the minor to protect their inheritance and kind of cut through the red tape that gets put on there when the plan isn't adequately thought through. So if you have a minor child in the mix, or a child with special needs, or an adult with special needs, any kind of incapacity issue, you need to get a lawyer to help you. If you have a blended family, so if it's your second marriage and your spouse's second marriage and you both have kids from prior marriages, you need to get a lawyer involved, because that is just like a recipe for fighting. When the first spouse dies and that deceased spouse's kids are wondering what's happening to dad's money, and stepmom is using the money but the kids want the money, and it just causes conflict. And we all know, as we have gone through and experienced loss, that we don't always act our best. We're not always on our best behavior when we're grieving and when there's money on the table. So if you are part of a blended family and you're working on your estate plan, talk to a lawyer. If you want to make some charitable gifts, you can probably do it yourself, but if you're wanting to, it's really tricky to identify charities correctly. And charities that exist now may not exist in 25 years when you pass away, or 45. I don't know how old you are. So it's important to think about, because we always want to have another place for something to go. If your will says everything to my kids, okay, well, what if there's like a meteor strike at the family picnic and there's no kids? Who's next? We always have to think about who's going to be next. So it's important to have a lawyer involved if you're having any of these kind of complicating things. If you have multiple beneficiaries who are not your children, but you have children, you're creating an unnatural disposition. You're giving outside of your natural line of issue. And so that could cause conflict too. If you have more than $2 million, you probably need to talk to a lawyer. If you have a toxic or complicated family dynamic, or if you're disinheriting someone in your family, you need to talk to a lawyer. And then if you have a privacy concern, like if you have a stalker, or if you're a public figure, or if you're in a line of work that has a lot of risk involved, like a lawyer or a doctor or an engineer or anyone with a PLLC, like a professional license, then you probably need to talk to a lawyer for your estate plan. Yeah. Go ahead. It's really just, as you start creating a larger estate, sometimes people who make their own plan, instead of adding all the language they need, they start to piecemeal. I give my house to my mom, I give my car to my daughter, and I give my bank accounts to my brother. But what about your life insurance policy? Oh, what about you have a tiny percentage in the family business that you forgot about? And as your assets go higher than 2 million, as you start to have more complex assets, it's important to think about all the pieces and how they're going to work together. Like for myself, I ran a credit check on myself the other day for fun because I'm a dork, and I found out about a retirement account for my first year teaching. It was my first job out of college, and I had no idea it even existed, and there was like no money in it. I mean, a very small amount, public school teacher, minimum, contribution. I had totally forgotten about this account, and it didn't have a beneficiary designated on it, and it's not referred to in any of my, I like to think I'm like pretty organized, but I forgot about this account. And then I searched on Texas unclaimed property. Oh, that's not in my slides. Everybody write this down. When you're bored, go to claimittexas.gov. Pretty sure it's .gov, might be .org. Claim It Texas, and it's Texas unclaimed property, and do an unclaimed property search on yourself and see if you have any unclaimed property. There's oftentimes random stuff in every state you've ever lived in. Search that unclaimed property for that state and search yourself. Claim your property, it's free. Yes. Yeah, your friends, your parents. Yeah, yeah. Well, you can check if they did. You go back and search it. If it's still there, they didn't claim it. Yeah. As your assets become more complicated and as you gain more wealth, your assets tend to become more complicated. It's just more complicated to administer. It is. It's my favorite game. I learned about the unclaimed property division in law school. And when I was procrastinating, I would just search everyone I knew. I'd search my professors, I'd search my mom, search my grandma. I searched everybody. And then when you help them figure it out, everyone's happy to see you the next time they see you. So that's just, it's not legal advice, just personal advice. Depends on the attorney, but I mean, they should. But yeah, it's really when you do meet with an estate planner, they'll ask you about your assets because we're always thinking about taxes, estate taxes. We're always wondering if we need to employ some kind of tax strategy. If $2 million, if your estate is 2 million or less, you don't really need to be worried about that, even if you have 10 million or less. But if you forgot about, oh yeah, I do get a K1 from my family business that I have a small ownership percentage in. Well, how much is it worth? Oh, a ton of money and you have 20%. Oh, your estate is larger than you think. So yeah. Oh, nice.
So I put the property on the market, it was sold at a parcel. One buyer who had 2 persons close or close one rolled over to 22.
Yeah.
And I got the firm up now.
Oh, yeah.
Capital gains
Bracket.
that 2-year look at in the field that is your own property, primary.
Yeah.
Very property.
Mm-hmm.
A lot of people don't know that. I follow a lot of money. I learned so much from the NPR. Money in your life. And I follow things like that where I just learned so many people not know about it.
Yeah. Nice. Yeah. That is one compelling reason why you might want to inherit in a trust, right? Because anything that you inherit in a trust from your parents or from whoever is not included in your estate for the purposes of being eligible for means tested benefits or for estate tax purposes. So yeah, I heard a couple of people mention like, do I need a trust? Why would I do a trust? Why would I do a will? Having a trust is more complicated. It is. And there are some financial benefits to receiving your own inheritance in a trust, and that's one of them. Yeah.
Even if you think, well, there's no way because I've never owned property, there were the weirdest things on there, like electrical bill that they somehow overpaid.
Yeah, rebate.
Pay my parents back.
Yes.
Stuff that you can still claim.
Yeah, you totally can. Yeah, my dad bought like one share of Exxon stock when I was a baby and put it in my account, uniform transfer to minors account for me. And they had mistakenly sent one royalty check to me as a minor, and obviously couldn't cash it. And it sat in the unclaimed property until I was in law school, and then I found it, and $46. Oh yeah. Anyways, but it's free. It's free to request. Don't be alarmed when you do go to Claim It Texas. This is not meant to be a unclaimed property spiel, but since we're here, when you go to Claim It Texas, you'll find your property. It'll list out anything that's associated with you. It'll have your name and address. So that's how you know if it's yours. Because I mean, I have a unique name, so there's not a lot of Carlotta Garza-Kilcullens out there. But if you have a more common name like Karen Smith, there might be 12 Karen Smiths with unclaimed property. So look at the address, and is that somewhere where you used to live? Look at the issuer of the property and the amount, and then you click claim on all the ones that are yours. You fill out a little online form. You do have to put in your social security number. It's not a scam. It's for real, the comptroller. And then they'll email you another form. You fill out another form, and you submit like your last tax return or proof that that's you. They'll check your social to make sure it's actually the same Karen Smith. And then in a few weeks, you'll get a check in the mail. It's like magic. So that's what I'm talking about. Well, at the time, I was in law school. I don't have any money. It was worth it then. Okay. Yes. Yeah, great question. So there's 3 ways to transfer title to property after someone dies. One is through probate, under your last will and testament. Another is by contract, and a pay on death or a beneficiary designation is a contract. And then a trust is also a contract. And then the last way is under the common law, which is the state of Texas laws of intestacy. So if you die without a will and you don't have a beneficiary designation or contract, then the common law determines who are your natural heirs at law and the split of all your assets. So yeah, pay on death or transfer on death or right of survivorship, those are all contracts you can put on bank accounts. Or you can also do it on your car, actually. You can name a beneficiary in your car in the state of Texas. You can also do a transfer on death deed to your house. That is another way to transfer title upon your death. The thing that I don't like about doing that instead of having a will is that example I gave of that random retirement account that I forgot about. It's hard to know, did I get every single one? And what if there's one account that you forgot about, and then that account has $3,000 in it, everything else transferred automatically, there's $3,000 out there. Is someone really going to go through a whole probate process just to get $3,000? Because the process probably costs more. I mean, depending on who you hire, the process probably costs more to claim that than is in the account. And so sometimes clients are like my engineer clients and my CPA clients who are they're on top of it. That can work great for them, but not if they have minor kids and not if they're in one of these kind of funky situations, like a blended family. So it works great if you're single and you want to just give everything to your sister, or if you have adult kids and you just want to give everything to your adult kids, or if you're married and you just want to give everything to your spouse. That can work as long as you get every single one. But if you miss one, there's going to be a problem for anyone trying to claim that thing that you missed. Yeah.
But I set it up like that. Complicated, toxic family dynamic with my brother, who was executor. So I don't know if there's some.
Yeah. Well,
It's not my case.
yeah. Yes.
Is that always like the foundation of that property done on property?
You can. Yeah, you could. Yeah. And they're revocable. So if you do a transfer on death deed for, your rental house, and then you sell the rental house, then it doesn't matter. A quit claim deed? No. Quit claim, okay, I do not. It's quit claim deed. People sometimes call it a quick claim deed, but it's a quit claim deed. I don't like quit claim deeds at all. I do not recommend that you use one. A quit claim deed is like a, we're getting a little technical, but that's okay. So there's all these different types of deed. There's a general warranty deed, a special warranty deed, a warranty deed, and a quit claim deed. And a general warranty deed or a special warranty deed is what you want to use, because what it says is, I, Carlotta, I own this property. I promise that I own it, and I'm giving it or selling it to you. And if after I sell it to you, an issue is raised about what you own because an issue is raised about what I owned, I will help you defend and clear the title of this property. So if you have future problems, I'm on the hook for them. That's what a warranty deed does. But a quit claim deed says, whatever it is that I may or may not own, I give to you. And don't call me, lose my number. Basically, is what it says. So if someone gives you a quit claim deed for a property, if an issue in title comes up in the future, you're out of luck and you have to figure it out yourself. And
You're dead anyway.
well, why would you be doing a quit claim deed if you're dead? What do you mean?
I thought, I was just talking to a guy last week, an attorney.
Yeah.
And he was just saying that might be my best route with my property. If, I don't have children either, but if I choose, brother,
Mm-hmm.
you know, a sibling or a a nephew or something.
Are you trying to make a lifetime gift or are you trying to make an after death gift? Well, an after death gift, you should do a transfer on death deed. Yeah. A ladybird deed is like a transfer on death deed, but it's a little bit different. And people usually think about using a ladybird deed when they're doing Medicaid planning. So, and I'm not a Medicaid planner. That is a specialty, and so I've got limited knowledge about that. But for Medicaid purposes, if you own property, or actually, if you use Medicaid, not Medicare, Medicaid, which is a means tested benefit, and if you live eventually in a Medicaid like residential facility toward the end of your life, then there's a risk that MERP, Medicaid Estate Recovery Program, will come back and claw back out of your estate. So a ladybird deed is a great tool that Medicaid planners use because it gives away, and this is, again, we're like doing law school 101. It's really fun for me. So in your ownership of your property, we think about owning a property like carrying a bundle, like a handful of chopsticks. One chopstick is you have the right to exclude people from coming onto your property. Another chopstick is you have the right to build a structure on your property or improve your property. Another chopstick is the right to rent it out. Another chopstick is the right to occupy it. Another chopstick is the right to sell it. And all these chopsticks together make up property ownership. So what a ladybird deed does is it only keeps one chopstick and gives all the other chopsticks away to someone else right now. So I keep the right to occupy this property for the rest of my life, and I give all of the rest of the chopsticks away to whoever is named in the ladybird deed. So you keep a life estate, a lifetime ownership right, occupancy right of your property, and you give everything else away to your kids or your sister or whoever. That's what a ladybird deed does. And because of that funky little chopstick split, you can escape MERP, and it's an effective Medicaid planning tool. But it can be risky when you're young and healthy to do a ladybird deed, because what if you want to sell the property? What if you change your mind? What if you get divorced? So I would, that's like something you should talk to a Medicaid planner about if you're thinking that that's a good option for you. Technically, that's not quite right, because although for tax and eligibility purposes, that split happens at the time the deed is filed, it doesn't really, their remainder interest doesn't vest. They don't actually own the chopsticks until you actually die. So yeah, we're getting into the territory of, I'm not really sure anymore. So I can't, yeah. If you ask me more questions, I think I'm gonna say the wrong thing. Sorry. Okay. I love the questions. I do want to push forward a little bit because I got a lot of information for you. Okay, Who can probably write their own estate plan? We kind of talked about this. Single person with all adults, married couple, everyone's getting along great with adult kids. Single person who just wants to give everything to their sister or a charity. Married couple with no kids who just want to give it all to each other and then charity. So like white picket fence or very straightforward, no minors, no special needs. It is risky to write your own estate plan, but you can find a lot of information about this for free on texaslawhelp.org. I love Texas Law Help, and most states have something very similar. Like there's a California Law Help, and there's a New York. It's not called that, but I have a slide about that in a minute. But there are resources out there for free that you can use to write your own plan. And if you fall into one of these kind of simple, straightforward categories, then do it. Get in there. My next slide has another Texas Law Help plug. So there's also emergency and incapacity forms available at texaslawhelp.org. Just search power of attorney and they'll pop right up. And all of these documents, lawyers prepare them with your will. It's like part of the package, but you can do these yourself, and they're available for free. The main problem that people run into when they do a DIY plan is that they don't read the instructions and they don't execute the documents correctly. So if you do choose to do your own documents, read the instructions twice and follow them exactly. Because if you miss a checked box or an initial, then the documents won't work. So that's the main problem. So in Texas, the main documents that create your emergency and incapacity plan, naming the right people, are powers of attorney. There's a financial one called the statutory durable power of attorney, and then the medical power of attorney. So these are all lifetime documents that take effect during your lifetime in the event of an emergency. And really all they do is just they name those trusted decision makers to be there and be ready and have authority if something comes up. And recently, Sarah asked me, what's the financial benefit of having an estate plan? And I was like, I don't really think that there's a financial benefit right now, but there's a huge peace of mind benefit in having the right people in place, especially if you're single and have young kids, or if you have a difficult relationship with your parents or your siblings. Because under the common law, if you don't have these in place, who is your decision maker under Texas law? It's your spouse, even if you're in a pending divorce. Yikes. It's your, if no spouse, it's your adult kids. If no adult kids, it's your surviving parents. If no surviving parents, it's siblings. And most of us, maybe some of us, have a fabulous relationship with all of those people, but a lot of us don't. Or they're far away. Or how are you going to get in touch with them? Or my sister's a guru in India. I don't know. I don't have a sister, but hypothetically.
Yeah, exactly. So question on that for our single, no kids, no married, but every person that matters is.
Yeah. Yeah. You got to have each one and name that person and name one backup person just in case that's local, if you can. Because what if there's an 8-hour time change, right? And you're in a car accident and you need consent to get medical treatment. Yes. Yeah, talk to him. Yeah.
It's amazing.
Ooh. La 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 la. What? What are you talking about? What? Yeah. Yeah. Did you get compensated? Just saying. Girl, get compensated. Yeah. Yeah, talk to the people you name. Yeah, go ahead. Yeah. Yeah.
People that have to be like friends, right? Or something like that, or is
Yeah.
it go to like a cousin?
It wouldn't go to a cousin at that time. If it was really urgent, the state would have to get involved and appoint someone, which is a legal process, and you don't want to do that.
Okay, are these forms actionable if an attorney does not witness signatures?
Yeah.
If it's
just get them notarized. Yeah. Yeah, you can print all these out, fill in the blanks, get them signed and notarized, and they're effective. Yeah. Banks will get you. Yeah. Yeah.
Why is that? Like, what is the deal with
I encounter that a lot with banks and with like governmental entities like Thrift Savings Plan. Ooh, the VA, kill me. I mean, thank you to the VA for all the benefits, but also dealing with them is a nightmare if you've ever dealt with them. Yeah, I mean, if you have a lawyer helping you, your lawyer can do the faxing, but every bank has their own process. Some banks now let you submit things electronically, but I think it's just like a security thing that people want originals mailed or faxed, but yeah, that's a bummer.
So to your point about getting your will or whatever notarized.
Yeah.
So I had a friend die.
Wills need to be witnessed by 2 disinterested witnesses and notarized.
Okay, so what he did, anyway, so what he ended up doing, the nail one. And I'm like, dude, you can get a will, blah, 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 whatever. So he ended up typing it all up on his computer and printing it out and putting it in a safe.
Doesn't count.
Exactly.
That's not a valid will.
Exactly.
Yeah.
So family came to deal with his funeral, blah, 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 all that stuff.
Yeah.
They had to hire an attorney. Like,
yeah. Unfortunately. And if you do something like that, you try to do a DIY, but it's not a valid will. If you have a nice, cute family and everyone gets along, they could agree to adopt the terms of the will and do a settlement agreement to honor those wishes. But usually there's one person who messes it up. Yeah. You know, like one sibling who is in a bad financial situation or who just got divorced and is bitter and angry, or, you know, there's usually a problem.
Yeah, so if they said though, if he had written it all out longhand.
If he had done it completely in his handwriting, then that could have worked if he included all the stuff he needed. And that's called a holographic will. So in Texas, you either need it to be completely typed, witnessed by 2 disinterested witnesses and notarized, or it needs to be completely in your handwriting. And that is a valid will. But the problem with holographic wills is that they usually don't have everything in there that they need. Like they either don't name an executor or they don't deal with everything. They say, I give my house to my sister and my car to my brother and everything, you know, not everything else. They don't include a everything else clause, which is called a residuary clause. So if you say, you know, A, B, C, D, E, E, and you don't have like, and anything else that I own to Z, if you're missing that everything else clause, then it's not going to work. It's called causing a partial heirship, meaning there's property that's not disposed of properly. So the court goes through a determination of the heirs and distributes everything else to the heirs who probably aren't the people you wanted.
Yeah.
Yeah. Yeah.
Is it that you, like, does the first line go to your husband and then goes on to your husband?
It's only if you wanted to. If you're happy, you don't have to. If you want to name your spouse first, then you can. And oftentimes that's what people do. But sometimes there's one spouse who is getting dementia, or there's one spouse is just real bad with money and can't be trusted. Then name your son or your cousin or your whoever. Yeah, you don't have to name your spouse. The common law. Yeah. Yeah.
There's people who move in together.
Oh yeah, who aren't legally married. Yeah. Yeah.
Anyway, she's living with this guy. You need to protect yourself.
Yeah, put something in place. Oh, common law marriage. My God. Common law marriage comes up more than you think. In the state of, everyone thinks they know what it means because of Legally Blonde. That's not the definition of common law marriage in Texas. In Texas, there's 3 elements of common law marriage. One, that you cohabitate, meaning you live together. And one night only is sufficient. I know. 2, you agree to be married. And 3, you hold yourself out to the community and represent that you're married. So sometimes people will call me and say, I think I need a prenup. And I'll ask them like, oh, do you live with your fiance? Yes. Oh, or, well, how long have you been living together? Well, we moved in together 2 years ago. We had like a commitment ceremony and we file our taxes jointly and he's on my insurance and here's my Instagram wifey. And it's like, girl, you're married. You don't need a prenup. You need a postnup because you're already married. So common law marriage kicks in sometimes. And that is a legal marriage. And the sad part about common law marriage is that there's no such thing as common law divorce. If you are common law married, you have to get a real divorce in a court of law where they divide property. And those are the messiest. Well, and ones with minor kids. Those are really messy.
Okay, so she's common law married, even though she's saying, well, we don't call ourselves husband and wife.
Do you call him my better half, my ball and chain? Is he on your insurance as your spouse? Are you married filing jointly? Did you have a commitment ceremony? Do you wear rings? Do you post him as your husband? Anyways, sorry if any of you guys are surprise married and just finding out right now. Yeah. Yeah. You can get a document and file it with the county clerk, but you don't have to. But if you're trying to prove it, you have to, I mean, you can't just, yeah. Like if you're living with your long-term boo and you think you're common law married and he dies, then, and you know, his will gives everything to his kids. Well, and we're going to talk about community property in just a minute, but as a common law spouse, you own part of the property because you're married and we are a community property state. So then you would have to fight the kids and prove the elements of common law marriage in court to be able to claim what you own.
A couple across the street, they both in their 20s, brand new UT grads, blah, blah, whatever. They're renting a house across the street. So they're common law married.
Well, I mean, have they agreed that they're married? Are they representing to the community that they're married?
Oh,
You gotta have 3 elements. There's 3 elements that you need to have. No.
You know, presenting as a couple.
Well, I mean, that's really, it's not me who decides that, it's a jury, but you know, it's all evidence-based and everyone is different, right? Are you listed on Facebook as husband and wife? Do you file your taxes as husband and wife? Are you listed on each other's emergency paperwork, like with your work or with your doctor as spouse? Do you call each other Mr. and Mrs. or my old lady? Or do your grandkids think you're married? Like, you know, or do you just say, oh no, she's my girlfriend? Like, how do you talk about it to your family? Does your family believe that you're married? Those are all kind of questions that would come up.
I know that these things default to your spouse, but when my parents learned the hard way, that's not enough. So like, for example, when my mom was getting neurologically sick, it would have been a disaster if my dad had to then rely on her to like make his medical decisions. So it's really worth having a backup.
You've got to have, I suggest 2 backups. Yeah.
It just makes it much better if God forbid something happens to that other person's spouse, either medically or
or if they get Alzheimer's or whatever.
Right.
Yeah. Name a backup. Yeah. All right. If you are outside of Texas, here are some things that you can Google to find similar resources in your state. So like public law library, power of attorney, or California self-help, power of attorney, or New York City law help. Like all of these terms are the ones that search them a couple of times until you find a nonprofit like Texas Law Help that has the resources. These are the most common names of those websites. So that's what I would suggest if you are outside of Texas, or if you have property outside of Texas, then these are ways to find for yourself free resources that are like legit and not a scam. Okay. And now we're gonna talk about community property. So on my little screen, I have a map with community property states in green. Texas is a community property state. And the reason I'm talking about this is because you can only give away in your will what you own, which like sounds obvious. What do I own? I own my house, I own my car, and my bank account. But actually I'm married. So I actually only own half of my house and half of my car and half of my bank account. So let's talk about how that works and why it's important. So all these states that are green are community property states. All the other states that are blue are equitable distribution states. And you really only run into community property issues when someone dies or when you get a divorce. But I talk about death all day. That's my whole job. And so for our purposes, we're going to be thinking about it as if someone was dying. So when you are married, all property that you acquire during the marriage is presumed to be community property, meaning that each spouse owns an undivided 50% of that asset, unless you owned it prior to the marriage or you got it by a gift or by inheritance. But all of your income is community property, and that includes income on your separate property. So if you inherit a rental house from your dad and it has a mortgage on it, and that rental property is rented out, it's generating income, you use the income to pay the mortgage, and it's doing its own little thing over here, and you are, working your job and your spouse is working their job, and then you get a divorce, you might think that this rental house over here is safe and sound because it's separate property, but actually this separate property has been producing income, and income is community property. And you've been using that income to pay the debt on your separate property. And that creates an alienation claim for your surviving spouse of community property, a reimbursement claim on your separate property. And so when people get divorced, that's why like in rap songs, it's like, but when she leave your ass, she gonna leave with half. It's because, thank you. It's because you don't realize it's not half of all of it, but it's half of what's the community. And the community property piece, it's insidious, it sneaks in. If you have an investment account that receives dividends and those dividends are automatically reinvested, then that investment account, even though you had it before you were married, I see some angry faces in the crowd. Thank God. Yeah. So any of that income is community property, and that's why divorce and death can cause a lot of problems, especially when you're in a blended family. So if you have, we're going to use normal, not normal, that's the wrong word. We're going to use heteronormative gender roles just because that's the default in my documents, but obviously love everybody. So we have husband and wife, both of them are on their second marriage, and they don't get a prenup. And they all have kids, and husband and wife agree like, oh yeah, I'm just gonna give everything to my kids, and you got your own money and I've got my own money, and we'll just keep it separate. But they don't put it in paper. And then, wife gets dementia, and so daughter is acting as wife's power of attorney. Husband's will gives everything to his kids, and then he dies. Okay, well, what's gonna happen? Power of attorney, daughter for mom, is going to say, well, I know it says everything to your kids, but actually mom is entitled to half of the community property and also a reimbursement right, a claim of reimbursement for any separate property, that income on separate property that was reinvested. So then you have to get a forensic accountant and you have to go back through and clean it up and make sure because daughter, who's doing a great job advocating for mom as power of attorney, is totally blowing up this plan. And so it's important, that's why the blended family thing comes up all the time. It's really important to understand what you actually own so that you can actually give it away effectively. And one way to know what you own is to have a prenup or a postnup, which is like a property agreement that you enter into a marriage with, designating what's separate and what's community. And another way is to have a lawyer help you figure it out, or to do an asset by asset designation. But what most people end up doing in that messy, kids of husband and power of attorney daughter of mom, what they end up doing is fighting about it, and then they spend too much money, and then they settle. So it's cleaner if you put it all out in paper beforehand. Yes.
Just to confirm.
Yeah.
Property that you own, house, car, whatever, before you get married.
Yeah.
Is not.
That is your separate property. But any income that generates is community property. And what you do with that income, if you reinvest it in your separate property by paying a mortgage or paying the property taxes or whatever, that is what causes the reimbursement claim. I mean, prenups can be tossed out if they don't pass muster. So a prenup has 3 elements. Guys, can you tell I was a teacher? A prenup has 3 important elements. One, each party is represented by separate counsel or has the opportunity to have separate counsel. So spouse 1 has their own lawyer, spouse 2 has their own lawyer. You have a full disclosure of the assets, because anytime you're waiving a marital property right, you have to know what you're waiving. So you have to list out all your assets, both spouses, and all your liabilities, all your debts. And then the third piece is time. You want to make sure that you have plenty of time for both parties to review it and sign it. Otherwise, if you slap it down in front of your fiance the night before the wedding, and if they don't sign it, they're going to lose their security deposit and they're under duress, then it can be tossed out. But if you have those 3 things, separate representation, full disclosure, and plenty of time, then prenups, yeah, they'll work. Unless they have like an unconscionable element to them, like if you're trying to make a contract about child support, like you're not allowed to make any kind of agreement about or restrict anything to do with a child. Yes. Mm-hmm. That's one reason why you might want to leave that inheritance to the child in a trust, because another separate property, it's something you inherit, but if it's generating income, then if it's contained in a trust that you leave for your child, then everything within that trust will not be subject to division in the event of a future divorce of your child.
They file the tax. Like some of the IRA. So with that 50 house.
Well, if they're taking distributions, they need the money, right? If they're taking distributions out and using it to pay for their life, you want them to do that. So I guess the next question I would ask is, well, how controlling and how protective do you want to be over what's in that trust, right? Because depending on the level of control you want to have and the level of protection you want to put, I mean, you can make it more protective, but as it becomes more protective, there's more administrative expenses. And do you really want to, are you sure you want to set that up, right? I typically tell clients, like, you got to trust your kids at some point. But if you were really concerned about that, there are things you can do to protect the income. But I mean, the money is there for the kid for a reason. Oh.
And then the balance each age 6. So, no, it's
But
really,
it's so, it's a little bit
I don't know, I don't know if that's the right thing. One is never gonna get married, and one is going or which makes
I mean, as distributions are made, so a trust that you inherit is an irrevocable trust. And everything that's in the trust has beautiful asset protection on it. Protection from creditors, protections from lawsuits, and protections against divorce. Once it's out of the trust, you lose the protections. So what I typically advise, although everyone's different and all the assets that you're working with are different, right? Like if the daughter's trust is going to be worth $3 million, let's keep it in that trust, baby. Let's protect all that. But if your daughter's going to inherit $200,000, then it probably doesn't make sense for her to be paying the administrative expense to keep it going for a long time. So that's really where it's helpful to talk to a lawyer about and say, this is how I imagine it going, but what am I not thinking of yet? Or what should I be considering? Because that's really going to depend on the value of the trust that they're getting, their own personality with money, like their own ideology, financial ideology, and their family dynamics. And everyone's different. And it may be that your daughters need different trusts to meet their individual needs. So maybe talk to a lawyer. Yeah.
So that estate aunt died, uncle died before she did.
Mm-hmm.
They had a trust for a couple, I don't know, it was a lot. But one of the things that I ended up finding out, so they used to live in California, they got rental property in California.
Oh.
They moved to Arkansas.
Okay.
They both died in Arkansas.
Okay.
She died before she did probate. Of the 6 rental properties, 2 of them were in his name only. After they got married, I still wonder to this day, I would have loved to be a fly on the wall how she got her to sign that paperwork, but she actually did. So I've got a cousin, a granddaughter, who I got through a lot of stuff, and she's still fighting through all of what she's got to do in California. The trust where my aunt ended up being the only trustee that he didn't know it existed.
Oh, yeah, I'll do
We
it.
thought the property was in a different trust.
So sorry to hear that.
The 2 properties that are in her grandfather's name only.
Oh.
So there's all of those things.
In the uncle's
now
name
she's
only.
having to deal with. And like Arkansas probate, you got 5 years to do probate. California, they don't care. It's like probate goes on forever.
Yeah, it does.
Or you have the capability to do it forever. And so it's like, how do you set those things up? It really does.
It matters.
Matter a whole lot.
Yeah.
Of, and court will be involved a lot depending on
where you are.
Deal with it.
Yeah. Yeah. And I mean, forgetting community property for a second, just looking at this beautiful map. So yeah, every state has their own probate process. It's different in every state. Here in Texas, our probate process is pretty good. It's pretty efficient. And we have something called independent administration here in Texas, which means that once the executor is appointed, they can sell, they can buy, they can distribute, they can pay taxes without having to ask the court for permission. But in other states, there is no independent administration. The executor has to ask the court for permission to sell, and they have to ask for a minimum sales price, and they can't sell below that price, and the court has to approve the sale. And there's so much more administrative BS that you have to go through in other states. Every state is different, but here in Texas, if you only have property in Texas, you don't have a condo in Florida, and you're not inheriting your mom's, Montana ranch, and you're only in Texas, then a will probably get you where you need to go. But if you own property in another state, that's a great reason to set up a trust while you're alive, a revocable living trust, that you put that property from another state into while you're alive. You just execute a deed, not a quitclaim deed, a special warranty deed, from yourself, Carlotta, myself. I give my property in Florida, which I don't have one, but if I did, I would put it into the Carlotta Trust, and I would give it from myself individually as grantor to myself as trustee of the trust as grantee, file it in the deed records, and then that property is in your trust. And a revocable living trust is not a separate taxable entity from you while you're alive. It's connected to your same social. You don't have to disclose it to the IRS. It doesn't impact your income taxes at all. It just holds title to properties around the US. Trusts are treated differently in other countries, so you got to talk to somebody else about that if you're going to inherit something in Mexico. But if you have property in another state, or if you own a house half, with your brother in another state, consider setting up a trust and putting your half in the trust while you're alive. Okay, I'm doing okay on time. Because if you're subject to probate in multiple states, it's going to be a huge bummer. I'm so sorry for you and for your niece. Yeah.
Like if you separate it out by increments, like age 20, age 25, things start getting released. What happens if God forbid something happens before that, or like there's an emergency and they need the money, like there's a health problem, or is it something they can amend, or no, it's literally whatever you said before you died and that's it?
So trusts, let's talk about trusts since we're talking about trusts. There are three important people involved in a trust. There's the creator of the trust, the settlor or the grantor. There's the manager of the assets, that's the trustee. And then there's the beneficiary, who the trust is for. And those three people work together to create this trust. And the trust is going to have a distribution standard. And the distribution standard is going to tell the trustee how to use and distribute the money in the trust. So, and someone mentioned earlier, I think it was you, that trusts are taxed differently. Their income tax rate for trusts is higher than the income tax rate for an individual. So most trusts that you would set up for a child under your will, or for whoever under your will, or an inherited trust is what I should say, those are irrevocable trusts that, because the person who created the trust has died, that's the trigger event to create the trust. That's an irrevocable trust. So then there's the trustee and the beneficiary. So the trustee is going to follow the distribution standard in the trust. That's going to tell them what to give money to the beneficiary for. And there's usually going to be language in there encouraging the trustee to distribute the income out, because if you keep the income in the trust, it's going to be subject to the higher income tax rate. But if you distribute the income out, the income will be taxed at the individual beneficiary's tax rate, which is usually lower than the trust tax rate. So the most common distribution standard is health, education, maintenance, and support. HEMS, health, education, maintenance, and support. So if a health issue came up, the trustee would have in their distribution standard health. So they would distribute for that person's health and pay their bill or whatever. Or education if they want to go to graduate school, or if they lose their job and they're worried about paying their mortgage, right? Maintenance and support. That's what that's there for. So the trustee should use the distribution standard and their own discretion to make appropriate distributions. So instead of saying, I'm putting, I'm just going to use easy numbers because math on the fly in front of a lot of people is like kind of hard for me. Let's say there's $100,000 in the trust, and in the language of the trust it says she gets 25% when she's 25 and 25% when she's 30 and the rest when she's 35. Okay, sure, but do you really want to keep everything else in there except for those times that it distributes out? There's probably a distribution standard in there that says, in addition to these, milestone distributions, you can also make distributions for health and education, or for whatever, one of the HEMS, one of the HEMS letters. It's different if it's a special needs trust. If the beneficiary has special needs or is an incapacitated person, it's a different standard. But the most common standard is HEMS. So yeah, okay.
For the trust, you have to pay the manager.
annual or some percentage, and then you have different tax rates?
So there's, we've got these 3 people, and what you're describing as a manager, that could be the trustee, and trustees are entitled to compensation because being someone's trustee is a big job. Trustees can waive compensation, like, for example, if my brother and his wife die, I'm the trustee for their kids. And, I would be writing checks to cover, and I would be investing it, and I'd be writing checks to cover, buy my nephew a tuba so he can be in the band or whatever. I'm not going to take compensation for that because he's my nephew and I want to preserve it for him and I'm his relative and I love him. But if that relationship isn't there, or if my nephew grows up into this crazy person who's suing me all the time, give me my money, where's my money, I'm suing you. Okay, well, I'm definitely taking compensation, because that's a lot for me to be doing. The other thing that people sometimes do when you're leaving a trust and you don't have that right person in place that you want to name as the trustee, you may choose to name a corporate trustee like a bank or a trust company. Banks and trust companies they have compensation schedules, and oftentimes they're listed on their websites. And it's like 2% for the first million, 1.8% for the second million. Like it's like cascading based on the size of the trust. And so, compensation, that does reduce the taxable income of the trust. Yeah. Okay.
If you said it was trustee, you writing the will with compensation. You set the compensation for that trustee, or who does that?
There's like 2 common clauses that you see in trusts, but you can customize it. The problem is if you're not naming an individual and you are naming a corporate trustee and you change the compensation and you say limited to X amount or not to exceed X amount, then your corporate trustee is not going to take it because they're not going to get paid. And then you're going to have a scramble of trying to fill that spot. So I don't typically advise having a really unusual compensation standard or clause, just because remember, this document's got to last your whole life and then your beneficiaries, till they're 25 or whatever age. And so we want to make sure that someone is in place who will take it. So the most common compensation clause in trusts is compensation for services actually performed in, I'm going to paraphrase, as is appropriate and common in the geographical area where the trust is being administered. So trust companies in Austin, what are they charging? That's approximately how much an individual could charge, or they could waive it. Or if one of those trust companies did need to step in, they could charge their customary rate. Or if it's being administered in New Mexico, what is a trust company charging in New Mexico? That's what you most commonly see. But when you're someone's executor under their will, the executor is entitled to compensation, and they can have that custom compensation clause that I just described, or the statutory compensation for an executor is 5%, but it's not 5% of the total estate. It's 5% of assets actually managed. So if you had to liquidate a bunch of stuff and pay a big tax bill, it's 5% of what you paid out and 5% of what you managed in. But if you're just transferring title, house from mom to house to daughter, you don't get 5% of that. It's only stuff that you actually manage in and out. Okay, let's talk for a moment about why you would do a will versus a trust, because I think that was one of our burning questions. So as I mentioned, in Texas, the most common tool is a will. You do a will, and when you die, your will goes through probate. And the probate process here in Texas is a pretty good, efficient process. It's affordable-ish. It's quick. And so what does that actually mean? What does the executor actually do? So until you die, your will is just a piece of paper. It doesn't have any authority to make a gift right now at all, only after it's admitted to probate in the probate court. So here in Travis County, we have 2 probate courts. So when you die, your executor hires a lawyer. They give the lawyer your original will, that wet ink signature page that you signed, hopefully in blue. That's what gets filed with the court, that actual document. It gets couriered. It's like we're living in the dark ages. It's the real piece of paper. If you have to do a copy, it's totally different and it's way worse. So original documents really matter here in Texas. So until you die, your will is just a piece of paper. Your executor files your original will and an application to probate with the court. The court does a little notification thing, and it's kind of funny. They like post on the steps of the courthouse that you've died, and they let people know. It's like a public posting, 10 days. And then your death certificate gets filed, and then you can have your hearing. The executor takes an oath, promises that this was your last will and testament, the only one, the last one, and that they'll do all the things they're supposed to do as executor. And then they get letters testamentary. That's the magic key to the kingdom. Those letters, it's like the ID card. I'm the executor. I've got letters. And that's what you use to access assets. So the executor's job is to find all the assets, all the bank accounts, all the properties, everything that you have, collect it, notify creditors, pay expenses and taxes, and then distribute to the beneficiaries, however the will says. Yeah. So previously, excuse me, previously it was the executor that notified them, but recently, when the death certificate is generated, banks are starting to get notice without being notified. This is a new thing that's been happening in the last like 18 months. So not really in small towns with like a local bank, but in larger branches. Now I have noticed that banks are being alerted more quickly that someone has died. And effectively what that means is they freeze the account. So that can be really tough if you are helping someone, helping your mom who's incapacitated as power of attorney, and then she dies. Well, when she dies, your power of attorney doesn't work anymore. And at that time, there's a gap. There's a gap in access between the access that you had as power of attorney, and then you got to file that will, get appointed as executor, and then you can regain access. Yes. Mm-hmm. A signature card.
Yeah, I remember that, but I was told if I had had a signature card, like when my dad had died suddenly, we were so focused on my mom.
Excuse me.
But then when he died, they wouldn't have frozen his account. Because imagine, at least for my situation, I was having to pay all of my mom's medical bills. So like I had to wait for all of that. I had to call and say, sorry, I can't send you the check because the accounts are frozen. Because he was paying for my mom's care.
Yeah.
So I don't know if that's something you recommend.
I mean, so signature card, it's used to give signer access, signer authority on an account. It can also be used to create a survivorship right, or a pay on death, or a transfer on death, or a right of survivorship. So it's a contract that gives you access and then ultimately can convey ownership upon death. So instead of having to get access through probate, you would get access automatically upon death because of the signature, the contract, the signature card giving you that ownership. And that can work, that can be effective when everybody's getting along and everything's going great. But if you had a bunch of siblings and then dad executed a signature card adding you as transfer on death or right of survivorship on all the bank accounts, that could cause a lot of issues down the line with siblings. Yeah. Yeah. Nah.
And I took her to all four banks. Can't do this because I inherit all of your money.
Right. It's a taxable gift. Yeah.
So good is
yeah. Mm-hmm.
Because I'm the honest child.
Mm-hmm. Right.
And so
yeah.
So it is true. Bank will
yeah.
You go back to later.
Yeah. And then you get access. Yeah.
So the transfer of death, car titles, I also did that with her. I
Mhm.
got her car title, I printed the document. Filled it out, took it down, $35 to transfer on death. That way you need ownership. I could sell the car.
Yeah.
And follow her. But if you're married, the spouse will automatically insert the car on the title.
That's not true. Not in Texas. Not unless you put it on there.
Yeah.
Yeah. No, not unless you put a right of survivorship on the title. My husband and I are both on the title of both of our cars, but there's no right of survivorship. So if I die, my half of the car is included in my estate for probate purposes.
Go ahead and ask the dealership to execute the title automatically to transfer on that.
One.
They're looking at you kind of thing. So that no one has. And you're just saying you need the steps in how to do it. So they can execute it, bought my daughter's car. I keep it in my name for insurance, but I did transfer on that for her. And I just received signed the car completely over to her.
I don't think you can do that if you have financing on the car, but you can do it if you buy a car in cash. If there's a lien on your car, like with a loan, I don't think you can do that. You go, girl. But if you do have financing, you cannot do that. But if you do die and your car doesn't have a designation, there's another way to get the car outside of probate. So it doesn't have to go. You would never probate someone's will just to get the car. There's another form you can use that is an affidavit of motor. It's a motor affidavit of heirship document that can transfer title to a car outside of probate. Yes. Yes, does have to be notarized. Yeah, read the instructions.
Can you have a situation? Don't have. Main beneficiary for all your financial accounts, and you have a transfer that you have.
Yeah.
And you have for your car. There's nothing really for the court to provide because you have specified and everybody gets along.
Yeah, yeah.
So you can.
Oh yeah, you definitely can. You don't. Not everybody has to go through probate. People who set up a trust and put everything into a trust during their lifetime, they don't go through probate. Or if you effectively do a beneficiary designation or pay on death on every asset, you don't have to go through probate. But the biggest problem I see with that is who's going to pay your final tax return? If you're making a lot of income, or if you just have taxable income when you die, where is the money to pay the taxes going to come from? And when you distribute all your assets out piecemeal like that, who ends up paying the bill? And that is what causes the problem. So, I mean, I just have run into this before. And so if you don't have a lot of tax liability, then how hard is the IRS really going to fight to get that money? I don't know. But if you do have a big tax bill and then you die and all of your property automatically transferred on your death, who's going to pay your tax bill? Whoever the IRS contacts and claws it back from. And the IRS has sticky fingers and they can get it. But then what if your beneficiaries receive the money and they go on a trip to Bali to commemorate your memory and they don't have the money and then the IRS comes knocking, right? That's a real problem. And so that's another reason why I don't like doing it that way, is because somebody's got to pay the bill, and it's not always going to be equitably shared if you do it that way.
With the person, so if you have a will, you name an executor, just for the purpose of them paying your taxes.
No, I mean, they don't have to. It's not necessary just because you're named as an executor in someone's will and they've died. There may be no reason to probate their estate at all. If the estate's not probated and the tax return isn't filed, in a couple of years, if the IRS comes knocking, they'll just knock on everybody's door who got the money. Well, it's up to you who you name. It doesn't have to be your executor. Anybody can file your final tax return. It doesn't have to be the executor. And if your estate doesn't go through probate, anyone can step up, and the IRS calls it your personal representative for your estate who does it. So that could be like a close friend, or it could be a relative. It just, if someone starts getting a call from the IRS that they have to pay back for tax liability, all the beneficiaries are going to get together and pick someone to do it and try to split it, but it just doesn't always work out that way. That's why if we're trying to avoid probate, I like to use a trust. Because someone is on the hook, right? It's the trustee. And before they distribute it out, they first have to pay the tax bill or the expenses, and then they distribute out. So everyone bears it semi-equally. So, yeah, we talked a little bit about probate. We talked a little bit about trusts. Yeah. Well, that's going to depend on how complex your will is. If everybody gets along, and if you have a will that works, if it's well written. If it's straightforward and simple, some firms will offer like a flat fee. I think probably the cheapest you could get. I mean, I don't offer a flat fee, so I'm trying to think, but I think probably the cheapest you could get would be like $3,500. And then the most expensive, I mean, TBD, right? If people are fighting and someone files another will, well, this is the right one, you have the wrong one, and we're fighting about it. I mean, the biggest legal fee I've ever seen, what was the biggest legal bill I've ever seen? I mean, like hundreds of thousands of dollars, right?
You could just figure if you have a will and you have a executor, you're going to be spending $5,000.
Yeah.
They're going to have that.
Yes. The filing fee in Travis County for filing a will, just the filing fee, is like $600. It's $580 and something cents.
That's what I call like the unromantic term of the business of death. It's like all those crazy weird bills that come out when somebody dies that you think, well, I've given everything away. Someone has to, like, if your parent or your spouse had we had a caregiver helping us, they still have to get paid for the last 2 weeks, you know, so it's like, or it's like if there's insurance bills or the mortgage is going to be due on the 1st and your person dies on the 25th, but you don't want to get penalized by the mortgage while you're like grieving and inheriting the house.
Yeah, medical bills, property taxes, electricity.
That's just I was kind of in a hard way. Was like I had no idea. Or like, are you creating? Are you bringing? Guess who wants money? All those people just to start the process. So
Even a headstone. I mean, a headstone costs like $5,000.
Yeah, that's why I was asking about that. Being like you're saying, if you guys set each other, whoever your loved ones when you're trusted people are up for success, maybe having one of them on a bank account that won't get frozen. Because gosh, what a headache when you have to sit there and be thinking about like, whether this is due tomorrow. Like I just saw somebody die, you know.
Yeah.
So it can be really stressful not to have someone have access to money.
I will say.
On auto pay, but then all that stuff.
Yeah.
Especially if it's for a checking account or the bank.
Yeah. I will say all those expenses are reimbursable to the person who paid them. And that's the first thing that the executor pays out once they get appointed. Like you have a priority of claims you have to pay. Number one is funeral expenses and last death, final illness expenses, so that the family gets reimbursed like quickly. And from time of death to getting appointed as executor, the fastest I've ever done it in Travis County was 5 weeks. So it's quick. And if you get these bills and you don't pay them for 5 weeks, no one's going to come and, take your car. But it is very stressful, and it's not just the financial bill, it's the emotional bill. Yes, ma'am. Girl. Oh, Arkansas.
There was ended up having to go through the judges for them to accept it to then finally deal with it.
Yeah.
So it was very
painful. And that's really the thing, is it is so different in every state. In Texas, it's great. In Louisiana, it's so bad. California, horrendous. So yeah, that is another thing. If you have real property like a house or land in another state, that's when you need to really start thinking about, do I need to avoid probate? How do I do it? Do I need a lawyer who's licensed in that state? Yes. Oh. Ooh, we're running out of time, you guys. Okay, well, I mean, I feel like maybe instead of just going through my slides, maybe I just take questions for the last bit of time, because I feel like, sure. Yeah, so a little bit about why you would get a trust. Property in multiple states is the biggest one. It's a privacy measure because you take property out of your own name and you put it in the trust, and it's not filed in the public record like a probate. There's no inventory that gets filed, so that's nice and private. Oh yeah, how much do things cost? Really depends. A simple will in Austin will run you between $1,750 to $3,000. Right now for me, if I'm doing like married couple with 2.5 kids, white picket fence, my going rate is $2,500. I'm on the higher end of, I mean, fortunately, but also unfortunately. Don't worry, I have all my friends listed on the last slide. If you don't have a plan, things can go badly. Yeah, and the biggest thing you want to avoid is an heirship. If you don't have a will, then instead of doing a probate, you do an heirship where the court determines who are the legal heirs. And oftentimes those people aren't the right people. And in addition to the lawyer who files the heirship, there's also an attorney ad litem who's appointed by the court to represent minor, unknown, or incapacitated heirs. So it's double fees. That's why heirships are a huge bump, one reason why. And if you don't have a plan, this is what can happen. And kind of the worst case scenario is a blended family heirship with minor kids from multiple marriages. And the story I always tell is my dad's best friend died unexpectedly of a heart attack when he was 50. And he had 2 kids from a prior marriage, and then he got remarried and had a little baby, and then he died. And so we've talked, I'm just going to get in front of it. So when you're married, remember we do community property. So if you're married and you only have kids with one spouse, first marriage, all your community property goes to your spouse. But if you're married and you have children outside of your marriage when you die, like a second marriage situation, but you have kids from a prior marriage, all of the deceased spouse's community property goes down to the children. So the surviving spouse, effectively their net worth is cut in half when their spouse dies. I know, crazy. So it goes down to the kids. So the surviving spouse retains their own half of community property. But again, now I'm stepmom and I own my house that I've been living in with my husband who just died. Now I own it half with his daughter from his first wife. Are you kidding me? It's so bad. And then separate property, separate personal property, so like your furniture, your jewelry, 2/3 to your kids, 1/3 to the surviving spouse, and then your separate real property, so like your inherited rental house or your house that you owned before you got married. The deceased spouse's separate real property goes all to the children who take equally, but the surviving spouse gets a third life estate. What's a life estate? Remember my chopstick analogy? It's one tiny chopstick, the right to occupy that property, but you can't sell it. You can't do anything really with it except for occupy it, and you're on the hook for property taxes and insurance. And so a surviving spouse all of a sudden is on the hook for all of these expenses, but their estate has been chopped in half because their spouse died and didn't have a will. So that's like always why, if you have a blended family, you have to get a lawyer to set up a plan to make sure that you're taking care of your surviving spouse, but also taking care of your kids. So that's like a very compelling example. The other ones are like kind of as you would expect. If you're married and you don't have kids, community property goes to your spouse, and then your separate personal property goes to your spouse, but your separate real property, like a house or land, splits to parents and siblings based on who's alive and with your spouse.
A question on that.
Yeah.
We have a will and they get married.
Yeah.
And I left everything.
Mm-hmm.
Now you're married, you have a spouse.
Mm-hmm.
You have will like that.
Well, your will can only give away what you own. And so if you make your will and you say, I give everything that I own to my mom, and then you get married, what do you own, right? You own your half of community property and your separate property. So if you don't update it and you get married and you're married for 20 years and then you die, there's 20 years, excuse me, of community property and 20 years of separate property that may or may not be generating income, which is community property commingling with your separate property and creating that claim that we discussed at the beginning. So what that effectively does is basically you die and then your wife and your mom or whoever go through a divorce to split the assets up. Excuse me. So you should redo your will after you get married. If you're unmarried and you have kids, it all goes to your kids. And then if you're unmarried, it depends on who survives you. Mom and dad, siblings, mom and dad, siblings, split up like that. Okay, I'm gonna skip ahead because I have another slide with resources that I think will be helpful. So those are like some options of estate plans that I like. Lawyers in Austin. Oh, I don't think I listed it. So these are my favorite lawyers, some of my favorite lawyers in Austin who do similar work to what I do. Diana and Catherine, stunning, delicious, love them. Catherine is an Army wife, and she does a lot of work with veterans and the VA, and she takes legal insurance plans. So I love her. They both do great planning, and it's like they'll have a lower rate for like the simple basics. If you need a more complex plan, like there's complex family dynamics, or you maybe need to avoid probate, or you're worried about some tax implications, then Caitlin Winters and Emily Yang are just a delight. And then if you need planning and you or someone you love only speaks Spanish, then my favorite is Melanie Ibarra Herrera. She is a true joy. So these are some of my favorite lawyers. Oh yeah, me too. Yes, I also do that. Yeah. Yeah. But last time I got like 15 inquiries right away. I'm just trying to share the love with my homies, my besties. But I do speak Spanish as well, and I take Spanish language clients. Yeah, so these are some of my favorite attorneys that do similar work, and these are like their niche areas. And then I thought that I had another slide, but all these charts that we talked through at the end, these like who inherits, these are all available for free on the Travis County Probate Court's website. So you just Google Travis County Probate Court, click the website, and then there's like at the bottom of the page, it's like, what happens if I die without a will? Who takes? Click. That's this document. I just stole it. Oh, great. Okay, thanks. Yeah. Yeah. And so I know I've given you like a lot to think about. So yeah. Oh, me. I did not include my, maybe go back and see. God, that's a lot of slides. No, it's not. You know what? I'll just type it. Okay, and then how do I put it back? Oh, it's very small. My email is cgarza@hvwlaw.com. You can also Google me and I'll pop right up because I have an unusual name. Yeah. And the best way to get in touch with me is by email. Yes. Yeah. Sorry to hear that.
Is it unusual for the executor not to have a copy of the document? Because she's never offered to share them with me. She only totally told me what's going to happen.
Nice. I mean, sometimes parents don't want to be a burden, and so they don't want to share the documents, or sometimes they have a privacy protective feeling that they don't want people to know. So I will tell my clients, make sure that your executor knows where the documents are kept and how to access them. And I don't like people to keep it in like a safety deposit box, because again, when banks find out that you're dead, and they're finding out quicker and quicker these days, who's going to be able to get in that box? Nobody. And so I typically recommend that you keep your estate plan once it's executed, because again, in Texas, we care about original signed documents. Keep them in like a fireproof box, like a safe in your house, and share the code with your executor, is what I usually say, because no, clients don't always want to give a copy. Have you already been appointed and taken your oath, or do you just know that you're named? Oh, great. Sorry, I thought you said that she had passed. I think I misheard you. Oh, yeah, well, I can't help you there.
Well, if there's feud going on.
Oh, no,
Passed away.
I don't like to fight. No. You should call.
Will is, yeah.
I'm a lover, not a fighter. You should call Emily Yang if you want to fight. That's not for me. If someone wants to fight, call Emily. She'll help you. She's your gal. I do not like to fight. I like to put all the pieces together and build the puzzle after the fighting is done. Yes. Yeah. So there's a few ways to accomplish this. One is a corporate is named in the will, and so all the individuals who are named, like daughter, husband, whoever, decline to serve. So then the corporate trustee steps in. Or if there's no corporate executor named, like a trust company named, then whoever is the executor can waive compensation, and they can hire a trust company. The trust company won't be the actual executor, but they'll serve almost like a power of attorney for the executor. They'll serve as the executor's agent, and then they'll do the work. But you do have to pay them a fee.
It's so much work.
It is so much work. Oh, yeah. It's a lot of work. Yeah. The only hard thing with professional executors and corporate trustees is just like the fee. And a lot of them have a minimum. So they won't take it unless it's X amount of assets, and each one has a different minimum. And I mean, personally, I prefer working with a small company that serves as executor, like a local trust company, over a big bank, because there's so much red tape you can't even imagine. I'm currently in a 2-year battle with my nemesis, this one trust company. It's a big national bank, and they're just so hard to work with because every time it's a different person. And yeah, whenever I am advising a client to name a corporate trustee, I'll usually introduce them to like 2 options and let them choose. And it's usually a local, smaller company. Yeah. Yeah.
I have a co-shared property that crosses 2 counties in Texas.
Mm.
I also live in Williamson County, so I've got Travis, Burnett, Williamson County in my. Do you recommend getting an attorney from each county? Is it that different in your opinion?
No. As long as it's in Texas, that's fine. But if it was like on the border of Texas and Oklahoma, then that would be different. But different counties is fine. And most lawyers will do a couple of counties. So
your license only in the state of Texas?
Yes. I mean, some lawyers maintain licensure in other states. I don't. But I did take the universal bar, which is accepted in 23 states. I could become licensed in another state, but the rules are different in every state, and there's such a malpractice risk to me of having to know all the rules. I'd rather just get co-counsel in Georgia or wherever. Yes.
Let me ask you a question. If you have named beneficiaries in the transfer deed, then you also have a will. You have to be sure that the beneficiaries, the will are the same as the ones in your financial transfer deed. Otherwise, I've heard that the beneficiaries on names of beneficiaries in the financial investment and transfer deed trump anything in the will.
Yeah, it's a contract. Yes, so 3 ways to transfer property: probate, contract, or common law. Contracts go first. They're not probate assets. So your executor doesn't have any authority to touch an account that had a pay on death or a transfer on death. That doesn't mean that people can't fight about it, but it does mean that it won't pass through your probate estate. And that's also the problem where if you name pay on death on all your bank accounts, but not a property, okay, well then what's your executor going to use to pay the bills? You just have a piece of land. Who's going to pay the property taxes, right? And so I'm always hesitant. One account is fine, but if you're trying to do these kind of piecemeal things, some assets cost money and have expenses and some don't. And whoever you're putting in charge as your executor needs cash available to do those things. So it sounds like you know what you want to do. Do it. So if you name a beneficiary on your investment account and your checking account and your saving account to Amy, and your executor is Johnny, Amy has all the cash and Johnny has a house. How is Johnny going to pay the filing fee and pay the lawyer and pay for the tax return? Johnny's either going to have to sell the house or he's going to have to find a way to make it cash flow, rent it out maybe. But that's a lot of time and effort for Johnny when Amy already got all the cash. Yeah?
This was so awesome. Oh, sorry. One more.
Last question. Oh, sorry.
My voice stays with you one night.
You need all three. You need all three things, right? Cohabitation, agreeing that you're married, and representing to your community that you're married. So if you only have one, you're totally fine. Yeah. Sorry. Just minor. This one? Oh.
Carlotta, this has been so great. Everybody, thank you so much for coming.
Yay! Thank you.
Send out the slides.
Okay.
And for a lot of